This educational program is intended for the personal, non-commercial use of its listener and may not be reproduced for any commercial purpose without the written permission of Rex Crandall and CALDA. The policies, positions, views and opinions expressed and/or provided herein are not those of the State Bar of California, CALDA, or any entity associated therewith, and are strictly those of the authors or speakers. No representations or guarantees of any kind are made with respect to the accuracy of the written, visual, oral or audio portions of this presentation, and nothing herein should be relied upon to answer any legal questions. The written, oral or visual information expressed or provided herein should not be relied upon in dealing with any specific legal matter. No attorney-client or CPA-client relationship is created by any part of this educational program and related activities. Attorneys, CPAs or LDAs using the information expressed and provided herein in dealing with a specific client or clients, and their own legal matters should also research original sources of authority.
Okay, so Kathy.
Yeah, I'm going to introduce our speaker, Rex Crandall. I think most people know Rex. Rex is a CPA, MBA, and JD. He's also an LDA, and he's had 14 years of experience with estate planning. He has over 40 years of experience with extensive tax preparation. He's worked with clients in front for the IRS, and not that we all want to have that someday. He's a certified registered tax preparer. He's also a real estate broker and extremely knowledgeable when it comes to wills and trusts. And I just want to say that even though the PowerPoint says chapter 3, it is in our course outline, it is number 2, wills and trusts. So go ahead, Rex. Oh,
okay. I wanted to share with you something I found out today, and that is we're putting all our materials on Google Drive so everybody has unlimited access to it. And during the entire program for the certification classes, you'll use the same link to get into that group of files. And you'll notice we had chapter 1 was the overview from last month, and we're using chapter 3, which is the chapter 3 in my book, and the folder on the Google Drive for chapter 2 is intentionally left blank. And when I always suggest people download the material before they start, it makes it easier and you get oriented. And for the homework, when you turn the homework in, you have the 10 multiple choice questions, plus each class will have a document, an estate planning document you'll prepare and submit. We have created a required homework cover sheet that must accompany all homework, and it has questions on criteria for you to answer, and it also has a place for you to answer the multiple choice questions. But after we put it on Google Drive, I wanted to point out that if you just click on the drive, Google Drive, the form is not fillable. But if you download the required homework cover sheet to your hard drive, then the boxes all work to be able to just write from your computer. So it's all going to be there in the same link every time. We'll start out with the history of wills. There were a lot of unusual laws in the beginning, way back, where people were not allowed to give their property to anyone else other than their family. It was originally intended for people who died without an heir under Greek law. And then other things, for Greek law, you had to be a citizen. slaves and foreigners just got all their assets taken away, and you didn't have a right to a will until you were 20 years of age. And of course, they were sexist back then. The will had to be distributed to the male children of the will maker, and the daughters had to marry the recipient of the bequest in order for her to get anything. Just as now, will makers need to be in their right minds. We call that capacity. And if someone's incarcerated or other law problems, they were not allowed to do a will. And there were requirements and attempts to keep wives away from inherited assets, various unusual rules. And for a while there, they were issuing the wills verbally and read out loud. Now we go to Rome, and the wills, our wills are effective only on death. You can't enforce a will until death. But under Roman law, it was effective at the time the will was created. And that is the same as our trust law. Those are effective when created. And they also tried to do the oral wills, and that didn't work out too well. And when somebody tried to give assets away from their own children or their own family, the law prohibited that. Oftentimes when they were using wills, is they were going to go into battle. So they would create a will at that time in case they didn't come back. At one point in history, you had to have 7 witnesses in order to have a will. And similarly, the family rules. Forced heirship. There's 2 kinds of legal systems, at least in the world, and the most common are the distinction between civil law and common law. Civil law are the jurisdictions where they only follow the statutes passed by the legislature and signed by the president or whatever the title is for the chief person of the country. And civil law ignores all court cases. In some civil law jurisdictions, it's more common to have restrictions on the ability to pass assets to beneficiaries. They have what's called a forced estate. But to contrast civil law, we live in a common law jurisdiction where the court cases have precedence and they're required to be followed of a higher court, and a lower court has to follow along. And we got that system from England. England's government structure is a little bit different than our government structure in that they have the House of Commons, which is like our House of Representatives, and then they have the House of Lords. The House of Lords acts like our Senate, but they have another role in that the House of Lords also acts as the Supreme Court in England. So it's a little different system. We received the common law jurisdiction, which we use today. Some countries have what I call forced heirship, and usually those are civil law. So I've listed some: France, Italy, Spain, Saudi Arabia, and Japan. And if you move to one of those countries, you might consider some other techniques for estate planning if you want to do something other than what the forced heirship rules require. So under Roman law, the executor had to be tied to heirship usually, and we adopted the words from English law: heir, executor, administrator, devotee, legatee, and slaves could not inherit under English law. And you could not disinherit your kids unless they had specific acts of misconduct. There were strict requirements for wills, and we got the word codicil from English law, and we have it still in English law today, but the codicils are not being used hardly at all anymore because of word processing. That's a codicil is an amendment of an existing will. The Roman will applied to both real and personal property, and then we come up with these non-common words like legacy, which refers to personal property, and devise, which has to do with real property. And English law was only effective on death, like our laws. And getting back into the whole history of the English law, our trust law came from England in the way that the friars in the church needed to have a nonprofit be in charge of their housing, so they couldn't have any assets as a vow of poverty. So they started creating these nonprofits, which ended up being trusts. And it was the workaround from the people who started the trust law in England. Okay, intestate, not having a will. It's not a crime, it's not a good idea, but I'd be willing to bet a very large percentage of people in the United States die intestate, and there's really no reason for it. As we'll look at it later, there's free wills you can get from statutes, and I think for people preparing wills, I think it'd be a good public service to prepare real simple wills for real low cost for people with moderate means. And the words that we use today are an evolution of history in terms of how we're using words today. When someone dies without a will, consanguinity becomes an issue, and that's basically bloodlines. The Spanish word for blood is sangre, and you can see the word sangre in consanguinity. So it is the bloodlines that are followed in intestate succession to decide who's going to inherit. When someone dies intestate, we have this chart that is available to us through the California Probate Code. And the way that it works functionally, it doesn't leave very many people out. So we start with a decedent. If they have children, it goes to their children. If the children have passed away, it would go to their grandchildren. If there's no middle beneficiaries here, it would go to the great grandchildren. And then the next row is started with the parents. Whether parents are alive or not doesn't matter. It would just go down to brothers and sisters, nephews and nieces, and so on. I mean, you'd have to go to ancestors.com to find out when you get out to these really long levels of consanguinity. And I had a kind of a revelation recently, because I've always thought that this is it. The table of consanguinity, somebody dies intestate, that's what they do. And then I came to the realization that's not it. This chart only applies to single people, because this chart I got from Calda, intestate succession, if there's no children, or it goes to the spouse, and by our California community property law. So if the decedent has a spouse and a child, then the surviving spouse does not get it all. They would get a half. And if there's 2 or more children, then it'd be divided out thirds between the surviving spouse and the beneficiaries. So it was a little bit more complicated than I originally thought. And this is the proper flow, but it's not represented on the table of consanguinity. So what is a will? The will only speaks at death. There have been cases where people have tried to enforce a will, change of terms and things like that before the person died. Courts don't accept it. The problem is you lose all lack of control if you don't have a will. And there are several ways to make wills. The best way is to make sure they're witnessed and detailed with your wishes. I always hear people say, oh, I got to get my will notarized. No, you don't want to do that. That's not the way that you do the wills. You get witnesses. So some people feel you need to be really wealthy to have a will. That's a myth. If you want to identify certain people to receive your assets and others not, you're going to have to list it. And a real important point that you should keep in mind is the will is the only place where you can nominate a guardian for minor children. So husband and wife have 2 children under 18. In the will, in each of their separate wills, you can nominate a guardian, an alternate guardian. And I use the word nominate because that's what you're doing. When the parents have died and a guardian is needed for a minor child, it is the court that appoints the guardian after a thorough background check. And if they have an unsavory criminal background, the judge is not going to appoint them as guardian. There are also times when you can use a will to reduce estate or inheritance tax. So there's a term in estate planning called a centerpiece, and that's just a term of art that people who have a trust usually consider the trust to be the centerpiece of their estate plan, and they might have another will to go along with it, a pour-over. But if you are not planning on having a trust and you want your will to be your essential estate planning document, then, and it's quite common and acceptable to use a will as the centerpiece for your estate planning. And especially under circumstances where you do not own real estate, you do not have minor children, you have not accumulated significant assets, and you don't have people who are dependent upon you, and there's a problem with unmarried domestic partners, that would be better to have a trust, which we'll get into. And another thing with a will, if you have really complicated assets like rental properties, cyber currency. We had one client who was a rapper, and after he passed away, his 7 children had all these music rights, and it went through probate. What a confusing mess with all these music rights coming from a lot of different vendors and who owns what. It would have been way easier to have a trust in that case. Another point, it's not an estate planning, it's more of a financial planning issue. If you have minor children, you should always have term life insurance to maintain the lifestyle for your children if the parents pass away. And I realize that that's not really an estate planning, but it's very important to maintain the children's lifestyle. Okay, so we have different categories of assets. Some assets go through probate, but not all assets go through probate. As we'll see, assets in a trust do not go through probate, but there are several other types of assets that avoid probate also. Pension plans, IRA accounts, 529 plans, Roth IRAs, life insurance, annuities. And with those kinds of assets, the vendor, let's say New York Life, you have a contract when you bought that policy or annuity or pension plan, and that contract says who is going to be your beneficiary. And you can put anything in your trust, you can put anything in your will, and it will have no impact on that vendor. Those assets are not going to be distributed any other way than the beneficiary statement that you signed up with the vendor. So other assets that can be transferred without a probate, California Vehicle Code, it's kind of scary really that if somebody passes away and there's a car, somebody just shows up and turns in a death certificate and says, I'm the only heir and I want you to transfer the car over into my name. Well, more than likely the DMV is going to do that. It's not as lax, as strict as other types of assets. Same thing can happen with boats, mobile homes, commercial coaches, but that's under a different, it's not under DMV. Amounts due from armed forces and salary compensation. With these other types of assets, the governmental agencies usually also have a pay on death provision that you can sign up with, and including paying the asset over to anyone you name, which also could be a trust. Avoiding probate. This rule just changed. If your assets have a fair market value of less than 184,000, then you are going to not have to have a probate. So it does not include the pensions and annuities, those items that we just spoke about. Other items that avoid probate or joint tenancy, but don't use joint tenancy because it creates a tax problem. In technical language, when someone dies, their value of their property goes up to market value, and only half of the property goes up to market value with joint tenancy. Sometimes people will die without a will. It's all community property. We can file a case called a spousal property petition. It's fairly straightforward, less requirements than a probate, much more efficient. A trust avoids probate, multi-party financial accounts. So you have three names on an account, one dies, the others own it. Pay on death accounts also avoid probate with your financial institutions. There is a pay on death real estate deed. I don't like it. I don't use it. The reason I don't like it is the beneficiary ends up assuming the personal liabilities of the decedent, not just on the real property if they received real property. So there's another procedure, and I've done one of these where you have small value real property for a lot. There's a judicial counsel form that we fill out, and you file that with the court, they stamp it, then you bring it over to the county recorder, and then you've transferred that small value property. If you want to look at some of the court forms, the detail forms, I've included those in the information about them, and also the link where to get those forms. So everybody talks down about probate is to be avoided. I don't disagree with that, but I think avoiding probate is overrated. And this is the way to compute how much it's going to cost in legal fees to handle a probate. So, and this is the max amount. So if you have a value of an estate of 2 million, the probate fees 4% of the first 100,000, 3% of the next 100, 2% of the next 800, down the line. And this is an example of an online probate calculator. There are many of them. So you don't have to do the math yourself, just do a search for probate calculator and you will come up with many choices. Now, this amount of fee applies in two ways. One, it's the maximum amount that attorneys can charge for probate services. They can charge less, but the law says this is the maximum. And the administrator or executor can also get a fee of that same amount. And oftentimes, the states we work with, the executor doesn't want the fee because they're going to inherit the property and they don't want to pay income tax on that compensation. We had a local judge here in the county that said, interestingly enough, if probate's the worst thing that happens to you in life, you've lived a blessed life. And there's probably some truth in that. Probate, pluses and minuses. The purpose of probate, in essence, is to get a signature, get a valid signature from a dead person. You may have heard it takes 10 to 18 months. Yes, it couldn't take that long. It is expensive. And as I mentioned, that probate fee is the maximum, but you can avoid probate through this affidavit procedure if the value of your assets are less than $184,500. Now, I don't like to oversell trusts, and because there are some advantages of doing probate that are not available in trust. Okay, so one is a probate, if there's liabilities for the beneficiaries on assets other than like loans on real property, it cuts off liability for the beneficiaries and for the executor. Another case I saw was effective was the woman had a minor child. There was no family members around. She created a testamentary trust so that she could avail herself from by the court supervision. And one of the reasons why I say trusts are oversold is I can't tell you how many cases I've seen where in a trust, they name a family member who's supposedly very honest, and then after the parents die, a lot of the assets disappear, they're squandered, they're stolen. And in that case, it costs way more money to have a trust than it would have to have a probate. One way to avoid some of that problem is in your trust, write out that you want to have a bond for the trustee in case any assets are missing. Other features of wills, executor does not have to have a probate. If you have small values, there's a form that we use. We call it from the probate code section 13100. So you present a third party with this form. It's notarized that you're entitled to the assets. There's no probate being processed in the court, and the third party is supposed to give the assets over to you. And if they don't, and you have to go to court, then the person who is withholding the assets from you has to pay the legal fees. I mentioned about nominating a guardian, and this is a really interesting point about Medi-Cal. So somebody's older, they have a will, they may go into assisted living, nursing care, and they get on Medi-Cal and they run up a bill at the rate of $6,000 to $7,000 a month for their care. And if they die without a trust and only have a will, the California Department of Health and Human Services will come back on the estate and claw back or get reimbursed for the money that they paid. It's huge. It could be $800,000–900,000. And since 2017, you avoid all that chargeback possibility by only having your house in a trust. And it's huge for seniors, you know, around the possibility of having nursing care. So another problem that you have in distributing assets, whether it's a will or a trust, is that children under 18 cannot receive assets over $5,000. The court and the law does not allow it. So you have to do something else. You have to create a guardian, which is a court procedure, or you invest it with the county treasurer, put it in a blocked account. But the easiest way to give money to a minor that meets the law is you create a California Uniform Transfers to Minor Act account and put an adult in charge as a custodian, and then the minor can receive assets even though they're under age 18. So what do you need to make a will? You have to have a desire to make a will. Your name, usually it's not required, but you say you revoke all prior wills. You nominate an executor and an alternate and another alternate so that you have coverage there. List naming guardians, list of specific gifts, which name an asset going to an individual, even assets going to a trust is a specific gift. You list out the names of your beneficiaries, and then a will always has a residuary clause that if all the other beneficiaries, we have anything left, give it to my heirs, which is like intestate rules. And then two independent witnesses have to sign that they saw the testator sign the will in their presence, and they both have to be in the room at the same time as both witnesses and the testator. There's been huge cases where someone was out of the room, they watched it later and it was invalid, but just follow the rules and it'll work fine. So California's got a statutory will that the same rules apply in terms of the requirements, and it's very rigid in terms of you're not able to change the document. You have to use it as it says, and we're going to cover a little bit about that. Holographic wills are allowed in California. That's a will written all in the testator's handwriting. And someone has to testify that they have affirmed that that is the testator's handwriting. And they're pretty lax on allowing holographic wills. It needs to show intent. It needs to have the handwriting verified by a third party. And you don't have to have a date on it, but it's a good idea. And it's not required for a holographic will. You do not have to have witnesses, but it's a good idea to do that anyway. So if somebody was going out of town and they're worried about not having a will and they just throw something together, do it all in your own handwriting and it'll qualify as a holographic will. You need to be careful of inconsistent wording in any will, including a holographic will. And sometimes people will do a videotape to prove that they were competent when they signed the will or trust. And oftentimes that backfires because it really shows that they're not competent based on what's shown in the video. This is something I see from time to time getting in estate planning documents. It's called interlineation, where somebody crosses out wording and writes in their own words. You can't do that because you have to follow the formalities that were used when the document was created. And by crossing things out, putting your initials on it, you're only creating problems, and that handwriting is not going to be followed. So I mentioned before, as people think they need to notarize a will, if that happens, your will's not valid because you have to have two witnesses. So if you're stuck on notarizing, that can be one witness, but you still have to have another non-beneficiary witness in order to make the will valid. Okay, wills have a thing called a self-proving affidavit, and we use this wording so that the witnesses of the will are not called into court and have to testify that, yes, we were there when they signed the will. And it basically describes that they were all in the room at the same time. They saw the person sign it. They looked like they were mentally competent, and they certified under penalty of perjury that that's true and correct. And with the self-proving affidavit, it's very unlikely that the witnesses would be called into court to testify that they really saw the will. And I give you an example of one. It describes how many pages, what happened, and then the witnesses sign the affidavit. Statutory wills, this is a model will. Only a few states have it. It came into law in 1991, and it's a little bit out of date, and it should be revised. But there's some problems in using the statutory will. One is the constraints that it cannot be changed or modified. The statutory will comes under Probate Code Section 6240, and you have to use it exactly as it's written. In the statutory forms, there's also question and answers that accompany the document, and it does work. It's low cost, and you can get them online. And for a do-it-yourself project, it works. And but it only works in certain situations with more modest means in the estate. Okay, so a standalone will means that you're not having a trust. It's intended to be the main part of your estate planning, and it works well if you're in a hurry. Pour over wills are what I see mostly because we create trust with assets over 184,500. And what it says, whatever you want to know about where I want my assets, put it in my trust. If my trust is invalid for any reason, do what the trust says. And it keeps pointing back to the trust. And that's why it's very few pages. Some of the problems with owning property in different states is you might end up having a probate in each state where you have real property. You can avoid that by having your property in a trust, even though it's located in other states. So there's some requirements that happen when somebody dies, one of which most people don't know, that a person that has a valid will in their custody has to file that will within 30 days in the Superior Court in the county where the person lived. And there's a filing fee. It's currently in 2022 of about $45. And in addition, you have to deliver a copy of that will to the named executor. And if a custodian of a will fails to do that, they might be liable to third parties. And it's a perfunctory requirement. It is in the law. I know of no penalty if you don't do that. I've never seen any litigation about it. So we talked about oral wills, electronic wills. Some people try to get really fancy and try to do, cyber wills. They're not valid. A video will is not valid. It doesn't act as a will, even if it covers all the words that would be in a will. It's just not meeting the statutory requirements. Joint wills are to be avoided. Husband and wife need to have separate wills. It's really a problem, especially if you make a contract to make a will. So husband and wife create one will, and then what if one spouse creates another will? Does it void the first one? Is the other spouse now getting detrimental reliance? And just don't do it. Each spouse gets their own will, although we do a trust for joint assets. A living will is just a bad term all the way around. It's really an advanced healthcare directive, and I try not to use the word. Bequest to pets. If you give a bequest to a pet, they can't receive it, and usually what happens is you give money to a third party, and they're not required by law to use the money for your request. Now, there is a thing in California law that allows for a pet trust to be valid, and it has to be drafted according to the code. And there's been some very wealthy people who have made pet trusts, and they do work. We frequently get people who will donate to Animal Rescue Foundation, and then the foundation agrees to take care of the pet after the person dies. You need to pick an executor. Who's your list of suspects? Friends, family. You can hire licensed professional fiduciaries. You can mix and match co-trustees. You need to make a determination if you think they're honest, that they have attention to detail, that they get along with people, and that they're going to follow instructions. And you might want to ask them if they want to be executors. Most executors and trustees that I talk with, after they're done with the whole case is closed, they go, boy, if I would have known how much work there was to do, I would have never accepted the job as executor or trustee. And they should be bondable. And so a bond protects the assets in case the executor or trustee takes the money. And if the money disappears, you file a claim with the bonding company, and then they reimburse the estate, and then they send somebody like Dog the Bounty Hunter to go and get the person when they're trying to hide out. I doubt that happens in real life that way, but the bonding company does go after and sue the embezzling person. Ethical wills is another misnomer. It's not a will. This is your way to get the last word in a situation, and the way I've seen it used effectively is to describe people's feelings, how they were grateful for people who helped them out during life, their family and friends. And it's a good way to communicate the emotional aspects. I think working with wills and trust, we get so caught up in the paperwork that you forget that this is really an emotional issue with everyone that goes through the process. And the ethical will is a way to describe things to your survivors. And I would put in their wording that you're not intending this document to change any other will or trust. Okay, so ethical wills, we said, are not really wills. What people have been asked about what's most important to them, they think usually it's not their careers or wealth, it's their interaction with their family and loved ones. Now, some people get fancy and they put an arbitration clause in their will. That has found to be ineffective. It will be unenforceable unless the beneficiary signs in advance that they're going to accept that. It doesn't happen that often, but it can. Digital assets are becoming more and more important, You need to give consideration to your online access, logins, passwords, so that like in our office, we pay a lot of bills by automatic transfer. Well, if you can't access the funds, the executor can't control those accounts. So you need to come up with some method for that to take place. When do you update your events? Maybe every 5 or 6 years. If you have a divorce, the will automatically cuts out your former spouse. And if you have a child, it'd be a good time to change your estate planning documents. And when you go to a new state as residents, to follow the laws of that particular state. You want to avoid any ambiguity that could be taken 2 different ways. What I'll do is I'll say it one way and then I turn around and say it the reverse. No, I did not mean this. Another thing to avoid is what's called precatory language, which means do it if you want to. I would like you to do this, which is way different than mandatory wording. The executor or trustee shall distribute this property to Animal Rescue Foundation. And so there's been a lot of litigation around this wording. It's so generalized and it causes problems. But it is possible you can give the executor or the trustee discretion to make up their own mind. No one knows everything about estate planning. There's a lot of different details and we're learning things all the time. And it's just something that you do, and all kinds of things. As you get into it, you'll see the different aspects. This is an example of the statutory will that you cannot change. And it's available online. It meets all the requirements because it's actually in the probate code, and it's fairly easy for someone to fill out if they wanted to do their own statutory will. It's not a lot of detail, and it gives some advice for witnesses. It is something that's available. We don't recommend it, but in a pinch, it would work fine. There's also question and answers related to the statutory will that you would want to read over and to avoid having problems in using it. When you're not going to do a probate and the value of the estate's less than $184,500, this is a procedure that you use to obtain the asset held by a third party, and like a bank. And so you have to have a death certificate, has to be notarized. You have to assert under penalty of perjury you're entitled to the property. And you present it to the third party. When we do these documents in-house, we add a paragraph before the notary of the law that tells the third-party holder of assets that if they don't comply with this, they're going to have to pay all the legal fees to enforce the document. We had one where a bank wouldn't give the assets over, and we went and filled out one of these, and after the bank got it, they just turned over the assets. In the statutory form, there's some instructions on how the various aspects of this form. We call it the small estate affidavit. Okay, so there's another procedure that we've used. This had to do with small value of real property. It's a simplified procedure. We've done it for vacant lots, land, places. You fill out this form and you file it with a superior court. It's called an ex parte filing, where you don't have to notify third parties, and then the judge signs it. When you get the document back, it'll have the court stamp down here. And then after you use the court stamp, you have to bring it to the county clerk or recorder and record this document, and that acts the same as a deed to transfer property to the rightful heir. So at this point, I'd like to see if there's any questions in the Q&A and see if there's things that could help clarify.
Yeah, hi Rex, can you hear me?
I can.
Okay, so I've been watching the Q&A. There's a couple of questions. If the will appoints a guardian, do we still need to open a guardianship case?
Okay, so a will, you nominate a guardian, and it does not take the place of a guardian. There's two types of guardians: guardian of the person, which is health, where they live, that kind of thing. And then there's guardian of the estate. And it does not take the place of a guardianship. That's the short answer.
Another one, is the will recorded?
No, the will is not recorded in the county recorder, but it ends up becoming a public record because it's part of the public record of the court.
And then let's see, let's go to the chat. There's been a lot of questions about chapters 2 in the material 2 and 4 that we know they're empty, so they will be filled in at a later time.
I'm not sure I understand the question. Could you rephrase it, please?
Oh, there's been a lot of questions about, and Chris has been answering the questions, but the material that you sent, there's chapters 1, 2, 3, and 4, and we know that chapter 2 and chapter 4, they're blank,
Right.
And they don't have any material.
Okay, so what that question relates to is we put the online material on Google Drive, and we're going to use that throughout the entire program. So you'll only have one link. And what you end up doing for each class is you go to the chapter with the alpha description, like this one is chapter 3 in my book. And on the online materials, it's listed under chapter 3. And next time we're going to use chapter 2 and put information in it, because that's going to have to do with trust, which the chapters end up matching the book that I wrote.
Okay, there's another question. It's about the homework. For the will, is there a specific program to be used, or can the program used in the be used? I'm not sure what that is. Maybe
I understand the question clearly. Okay.
You do?
Oh yeah.
Okay.
What we have is on the online materials, we have a course outline provided for you, so it shows all the class dates, what the homework is.
Oh, good.
And after that description of the course requirements, at the bottom of it, I give you references to a lot of different documents or software that you can use. It's up to you to decide how you're going to do the will. A good one that's low cost is a Nolo Press. I guess it's Nolo Quicken software. It's about $200, but I've listed several of them from professional level to beginning level. And you just need to figure out what you're going to do. Even a statutory will, it's your problem to resolve to create a will.
Okay, there's another one. Does our will submitted for homework need signatures?
Yes, we have a form that it's called the required homework cover sheet. You have to turn that in with all your documents, because we're going to be getting a lot of documents through this program, and also the multiple choice questions. So it's online with the materials. You get the required homework cover sheet, download it to your computer so you can fill it out, and then list all your answers on that and turn it in, and attach the document that you're sending either through email, service mail to our PO box, or fax, whatever is best for you.
Okay, another one. Can we use a pour over will for homework rather than a standard one?
Yes. A pour over will is a valid will. What we're trying to do is you're getting experience doing each type of the document. A pour over will is very common.
Did Rex say we should not use the word shall as in my executor shall?
No, what the discussion there was is be aware of words that, for lack of a better term, wimpy. So they're called, the term's precatory. So it doesn't require, if you feel like it, I want you to give this house to my kid. That's not enforceable. So you want to have unambiguous language in determining what you expect the executor to do. And if you want to make it optional, then what we usually write is the executor in their unfettered discretion can decide if they want to give the house to my kid. So it gives them the right to exert judgment, but I am completely against ambiguous wording.
Let's see, can we please go over the homework about creating a will, what program to use?
You can use any one you want. Let me see if I can come up with that real quick for you. Let me locate it first. Okay, so under chapter 3, we have the required course material. Okay, so item number 1F in the course material looks like this. And this is an outline of the course. It goes through what you need to do for each chapter. So we did overview, wills tonight. Next month, we're doing trusts. And then at the bottom of this form, I give you document preparation resources. So here's a software from Nolo. You can buy it at this link. There's other Nolo's Quicken software. You can use the statutory will. For trust costs quite a bit more. There's also for trust has a division called Adapt. I mean, this is quite expensive for professionals. And then I've given you links for the statutory forms. Another source for you is the Sacramento County Law Library. They have a wonderful collection of forms and explanations, but it's the challenge of your challenge. You need to figure out what you're going to do. If you want to invest $199 for the Nolo's Quicken Will Maker, it's up to you. You want to write it out on your word processor, have at it. There's no requirement on how you do it. It's only a requirement that you must do it. So hopefully that answers that question.
Does a trust have to pay student loans of the deceased?
Does a trust have to take the student loan?
No, pay. Does a
Pay.
trust have to pay student loans of the deceased?
Okay, we're not talking about trust tonight. Trust is next week.
Okay.
Okay, in a will, which is our topic tonight, when you have debts for the estate, the probate court, that's part of settling the estate, is you pay the liabilities that are due against the assets, and a student loan is one of them if it belonged to the decedent. So the judge is going to require that student loan be paid off before any distributions to beneficiaries are made.
Can you clarify a little bit more the situation where a decedent left a spouse and children? How are the percentages determined in regards to the inheritance?
Yes, I can. And what I would suggest, instead of me just reading this to you, it's in your materials. We have the slide deck. And if there's children, no spouse, here's the answer. The community property, you need to know what community property is. All property acquired during marriage, other than by inheritance or having it before. So these are the different steps depending on the family situation. And I'll just refer you, instead of me reading it, to the material, and you can read it.
If the will is public record, what's the best way to protect personal information such as a social security number, account number, and passwords, etc.?
What we do is we never put social security numbers in estate planning documents. And a will, you don't have to put those details in a will.
Okay.
And what we do oftentimes is, what we will do is, when we're talking about bank accounts or stock accounts, we frequently use the last 4 digits of the account, and that way the vendor can find it, but an identity theft person cannot. But nothing, you don't want to have that detail in your trust or in your will.
Okay. Does Medi-Cal and FTB need to be notified when there is a trust? Okay, well, that's a trust question we're not going to answer.
Well, when somebody dies, the FTB and the Department of Health and Human Services, and there's a list of agencies that do need to get notified of the decedent's death.
Okay, there's a lot more questions about homework and what software to use, and
I'm not going to make the decision for you. That's for you to figure out how you want to do a will, whether you freehand copy it from someone else, type it up on a word processor, buy software. You just need to resolve that problem. I'm not going to do that for you. Because some people might want to buy 4 trusts for $1,000, $1,400. Some people might want to do Nolo Willmaker software at $200. Other people might want to fill out the statutory. You decide.
And I put your email address in the chat box a couple of times, so people have it to send in their documents. And I think that's pretty much it as far as questions.
Okay. Well, that's the material that I have for you tonight. And if that's we're out of questions, then we'll go ahead and conclude. And I want to thank everybody for attending. And I look forward to getting your homework.
Great, and thanks, Rex. And we can hardly wait till next month.
Yeah, so can I. I get a big kick out of doing this, and I put a lot of effort in making sure that it's factual and has a lot of real world examples.
Great. Okay, thank you all for attending. Good night, everyone.